Welcome to the 2 weeks review for Remedies. At this point, we've gone through 2 weeks of coursework. The way the course is organized through the book can be a little confusing. I have actually taken that information and reorganized it to make it more digestible. So far, we have looked at compensatory damages, limitations on those damages, wrongful death actions, constitutional violations, and punitive damages, along with a few other miscellaneous matters. Compensatory damages are those that return the plaintiff to the rightful position. All that means is they return the plaintiff to the position he or she would have been in had there not been a breach or an injury. They're broken up into two subcategories, general and special. Special is sometimes called consequential and contract actions. The division into the two categories isn't really that important because what you really need to understand is what a compensatory damage is, what it's recovering, and how to calculate that. The general philosophy follows three interests, and these interests are reliance, expectancy, and restitution. Now, the first two, reliance and expectancy, are your normal theories found in compensatory damages. One of them, the reliance, just places the position back in the position they had been had the breach or injury not occurred. That's common for torts. Expectancy is what you will see usually in contracts, but not always. But if you keep your mind that if it's a contractual performance, that makes it easier. You're looking at what the plaintiff would have, that position that he would have been in had the contract been performed. So the expectancy at the time the contract was entered into. Then restitution, which actually isn't compensatory, it's its own form of remedy. With restitution, that's where you're returning the gains made by a defendant for the breach or tort. Think of unjust enrichment. We had the example in class where the businessman had wrongfully taken the invention from the inventor, ran off, was making crazy money using this invention as part of a process. Well, that money made from the wrongful taking of that invention would be the gains made by the breach or the tort. And those gains should be returned or given to the wronged party. And that's your restitution. Now, this is where it gets a little confusing with the general and special. Just try to learn the general flow of it. Torts and contracts have a little overlap, but where they don't overlap is where you've got the personal injury. Now, with personal injury, you've got your general damages, which are normally non-economic because they're uncertain as to the amount. You can be certain as to the pain and suffering and the disfigurement and impairment having occurred, the loss of enjoyment of life. These things are all things you can be certain have occurred. You can prove that. But what is the value of them? What are they worth? And that's the uncertainty issue you have to deal with personal injury. Now, two arguments come up out of this type of damage, and it runs into the per diem argument. We'll start there. And with per diem is where an amount is come up with to say $40, $100, $1,000, whatever numbers come up with on a daily basis is what this person should be compensated for that amount of pain and suffering they're going to have to deal with. And it'll be multiplied over their remaining lifespan taken from a government table. And those are allowed. The golden rule argument is not. The golden rule argument is where you ask the juror to be in the place of the injured party and for them to determine how much this pain and suffering will be worth based on their experiences. In other words, you're asking the plaintiff or you're asking the juror to take the place of the plaintiff. And whenever you see that kind of argument come up, you really have to watch out for it. Even in criminal law, putting the asking the juror to be in the place of the defendant. It's the same theory. They're not allowed. They're objectionable. And then your special. In personal injury, your special damages are actually economic. You can determine what the amount is. There's a certain amount to some degree. Medical expenses, especially past medical expenses, you know what those are. They've occurred. You've got bills. Future medical expenses, you'll have some testimony estimating what that's going to look like. It's got some certainty to it, but as we all know, medical expenses continue to rise. So take that with a grain of salt as to how certain those are. Lost wages, same story, and replacement of property, of damaged property. Now, with property damage torts, where the only part of the tort is some kind of destruction of property or damage to it or taking of, like conversion, this will look a lot more like your contracts. Here you've got your fair market value of the property, the replacement cost, the diminution of value, repair costs, and this can go on and on. I just gave a short list to give you an idea and a taste of what you're looking for. Then when you get to the special damages, it'll look a little different. Living expenses, for example, your house has been destroyed by the negligence of the defendant. You had to live somewhere. Well, the house is assessed and rebuilt, and those are expenses you should be able to recover because they are approximate results of the acts of the defendant, the tort, the destruction of your property. And then you've got loss of property use, cost to regain property and conversion. Someone's converted your property, meaning they've run off with it. You want it back. You've engaged some people to try to get it back, be a lawyer or whatever the law might be allowing you to go after this property. The cost associated with that you can get back as special damages. Now, there's some limitations with compensatory damages. And I just put these in here now before we got actually into contracts because it's a nice place for them to fit. The economic loss rule is going to only impact negligence plaintiffs. As long as you remember economic loss and equate that with negligence, it's really easy to keep all this straight. And what that says is if you have a negligence plaintiff and that plaintiff suffered no personal injury and has had no property damage, they can't recover for other losses. And this becomes important because if you look at the negligent infliction of emotional distress, that cause of action, there's a requirement that there be a physical injury for recovery. So you have to have that physical injury. And in case you're having trouble keeping it straight, negligence is in the title of the cause of action. Economic loss rule, negligence, what does this require? There you go. The confusion falls in where you've got the intentional tort of emotional distress, infliction of emotional distress. That's not a negligence cause of action. That's an intentional tort. So as long as you remember the economic loss rule, you're not going to get this wrong. Then the collateral source rule. This is important in calculating your damages because what's going to happen is you're going to want to get the largest damage award you can for the plaintiff, if you're the plaintiff's lawyer. And the defense is going to want to bring in evidence of funds received from collateral sources. Those are whatever third parties out there giving you money. They're going to want to count that in and try to use that to knock down the damages award. The general rule is they can't do that. The point being, they want to make sure that the plaintiff gets the largest compensation possible, even at the risk of somewhat double dipping. But there's another side to this. Even if you get the largest damage amount possible, you may have liens and other things you're going to have to satisfy once you have those damages. Liens for your health care expenses or whatever else you may have had to use to get through this time period. Then you have offsetting benefits. This is where an injury actually results in a benefit to the plaintiff. If that occurs, the value of that benefit can be used to offset the damages of the injury. Now, this may be limited to the same interest injured. So it's got to be a similar interest. An example is the government falsely accuses plaintiff of crime. The accusations improve plaintiff's notoriety, allowing plaintiff to get a movie deal. The value of the movie deal can be used to offset the injury of the false accusations. Now, with regard to property damage, you've got the lesser of two rule that you will run into. And what this looks at is what your recovery can be. And it's got to be the lesser of the diminution of the property's market value or its replacement cost. Whatever is lower, that's what it's going to be. There's an exception to this, specialty property. That's property that has no market value. It's designed and used for a unique use, and replacement costs, less depreciation, are the only thing that are going to get you back in the position you need to be in, because there's really no market value for this property. If you remember from the class, you've had the case with the historic church. They give examples of some type of beachfront bathing club, things like that, where they're designed and used for very unique purposes, where there's really no market for such a structure. Now, contracts. When you get into contracts, it looks somewhat like the property damage torts. You've got your general damages, which will be the difference in value, a refund of money paid, reimbursement to the plaintiff for expenses incurred, payment of increased costs to the plaintiff to correct, and it can go on. These are just, like I said, a short list I put together. And then your specific damages can be interest. They can be cost of extra labor. They can be lost profits. Now, the UCC, with regards to who breached the contract, has set up its own set of rules. Here we've got an example of where a buyer is trying to get restitution for a seller's breach, and then where a seller's trying to get restitution for a buyer's breach. We saw this in the case regarding the watercraft in the book. And in that case, the UCC decided that if the buyer needs to recover for the seller's breach, they can get the amount of liquidated damages or 20% of the contract value of $500 subject to offset. The seller, on the other hand, you take the market price, you subtract the contract price, add incidental damages, less expenses saved. And if that's not a good calculation, if it's not adequate enough to satisfy the seller's loss, then the seller can actually get the profit for what they would have made plus the incidental damage. And this came up in the world of high volume goods. They weren't specialty so much. It was a mass production type of market. Now, the avoidable consequences rule, or mitigation to make it easy, I put this under the contract section only because it's an easier way to think of it as in contracts. Yeah, you've got mitigation stuff under your normal torts, but if we discuss it here, then you'll see why it fits in contracts better. So the defendant's not going to be liable for avoidable consequences of wrongdoing. So if the plaintiff is able to avoid the wrong to some extent through their own actions, they have to do that. Now, look at the employment cases. And we had an example of this, but Ford Motor Company gives you a decent rule here. And they talk about reasonable diligence to find other suitable employment. It doesn't require that they go into another line of work or accept a demotion or take a demeaning position. The job must be, or should be, substantially equivalent to the one that they lost. And as time goes on, if the job is somewhat close, then you're probably going to have to take that. If you want a good example, look up Ford versus Nix and the sites down there at the bottom that'll walk you through an analysis for this kind of employment case and the mitigation required. Now, wrongful death is actually a statutory cause of action. Historically, if you died, any cause of action died with you. So state legislatures have put together statutes that will allow for these wrongful death recoveries. Normally in those cases, the plaintiff may recover out-of-pocket costs, loss of support, loss of services, and loss of society associated with the person who is wrongfully killed. The out-of-pocket costs would be things like your funeral expenses, things of that nature. The loss of support would be whatever was associated with as far as the support that the decedent had been providing. Same thing with services. So you don't have to be some wealthy, high-earning person to be worth a considerable amount in wrongful death. If you were someone keeping the house, if you added up all those services that you engage in to keep the house clean, take care of the children, the animals, whatever you have going on, that can become a very, very large amount of money. And then loss of society. Now, recovery for grief, mental anguish, emotional distress, things like that, a minority of states allow them, but generally they're not allowed in wrongful death claims. And this is in line with that tradition that normally a cause of action dies with the injured person. And then the other one to think of is loss of consortium. That should survive because that's a separate cause of action. Wrongful death is a cause of action of all its own. And then a separate cause of action is the loss of consortium. And the person who is claiming the loss of consortium is the one who's been injured by the loss of the decedent. So loss of consortium resides in the surviving spouse, the surviving children. You get the idea. Now, constitutional violations. Most constitutional rights are deemed to have an abstract value. So they don't have an easily determined value for damages, and therefore nominal damages, which is a very small amount, just damages in name only, it can be $1, just something, are what are awarded. Now, if you've had your constitutional rights taken away, and that loss of rights has resulted in other losses, then you can recover damages for those losses, the resulting losses. Think of it as, if you want to put it in the general damage and special damage world, the general damages on most constitutional violations will be that nominal damage, or make it easy, $1. And then your special damages can be rather large depending on what's occurred. This doesn't apply to the loss of voting rights. If you have lost your right to vote, then the courts have allowed substantial money damages. For some reason, they've determined them not to have an abstract value, but that's for the courts to keep dealing with. Just know that if you have a loss of right to vote, substantial money damages, and the limit on those will be a shocks the conscience kind of test. You look at it, compare it to other damages. Does the amount look insanely huge for what has occurred? That kind of limitation. Now, punitive damages are there to deter and punish. That's the reason we have them. You're looking for conduct that is intentional or malicious. It'll sometimes be so bad that it's incredibly outrageous. One thing to note is the only time that the defendant's financial worth or their net worth becomes relevant is if there's punitive damages on the table, because that can be used as a method of giving a jury an idea of what amount of money might actually be an adequate punishment or deterrent to this kind of conduct. Now, when that award comes in, there's 3 guiding questions you'll look at. The first is the the degree of reprehensibility. And that's the most important because you want to look at the defendant's conduct. So when doing that, you want to confine that conduct to what's happened in the state that you are in. You can try to argue it out, out of state. The Supreme Court has come down, as we saw, and limited that to in-state. And if you went out of state, you have to prove that this same conduct was illegal and stuff outside the state. So make your life easy, keep it in your state. And you may use evidence of similar conduct against other people. It doesn't just have to be against your client. If this person's going out engaged in this conduct against people throughout the state, that can come in. Then you're going to look at the ratio. The ratio is looking at what the amount is of compensatory damages compared to the punitive damages. Now, the reason you look at that is a majority of the Supreme Court has determined that due process can be violated by too big of an award. And the rule they kind of play with is a single-digit rule. And all that means is take the compensatory damages, and if the amount of punitive damages is between, just above 0 to 9, a single-digit ratio, then it should be okay with the due process. Now, if the conduct is really, really awful, you can deviate from that and get higher ratios. So you could have 1 to 15, 1 to 45, whatever, depends on the conduct. And the other thing that will happen is if the compensatory damages are really small, just because of the nature of the injury, but the conduct is just really awful, then you can get really large punitive damages compared to the compensatory, and that's likely going to satisfy due process. And then the third guideline is you're going to compare what you've got as far as damage to what a civil or a criminal penalty might be for this conduct that had been engaged in. And that's usually a really easy comparison to make because a lot of the egregious conduct either has no real civil or criminal penalty, or if it does, it's a really minor in the scope of things, such a small amount that the cost of doing it's just deemed a cost of doing business. So that's something you want to keep in mind. Now, here's the miscellaneous slide. There's one thing I haven't put on here that I want to bring up, and that's pre- and post-judgment interest. Normally, you can always get post-judgment interest. It's going to be calculated based on whatever the state statute you're in has come up with. California's got a cap somewhere around 7%. So the highest it can get is 7%. Other states have caps at 11, 12%. They're up there. Pre-judgment interest is normally allowed in cases where you have an ascertainable damage. So liquidated or ascertainable damages, numbers that are easy to determine at the time of the breach. However, they are allowed in personal injury and torts cases as well, and it's really within the discretion of the judge. It depends what the cause of action is and what's going on. So they do pop up in both. Remediator, that's where you've got the judicial lowering of the jury award. The jury comes back with a damages award. The judge looks over, decides it shocks the conscience or it's just not justified by the evidence given at trial, and they can actually lower that damage award. However, when they lower it, they should accompany that lowering with an offer for a new trial. So you can have a new trial or take the lowered damage award that the judge provides. Having said that, judges cannot raise the jury award. That's actually seen as violating the Constitution, being against due process. Taxes. This is just a little quick side note. Taxes are generally taken into account for lost wages in federal court cases, but not state court cases. Just keep that generally in your head. Don't go too deep into it. If you went deeper, you would find cases in federal court where you would not take them into account, but just for simplicity's sake, just remember it that way. Present value. This deals with future damages. When you've got future damages, you can ask a judge to reduce them to their present value. And the way that's done is there'll be a discount rate, which is an interest rate, that's used to reduce whatever this future stream of payments is estimated to be to a value in today's dollars. Now, if you have any questions regarding this material or concerns, please let me know. And if need be, I can come up with another review slide or set of slides to discuss it, or we can talk about it in class.